Alright, continuing our discussion about constitutional carry in Texas, I wanted to talk today very specifically about what is probably the most important statute, and that is 4602 of the Texas Penal Code. And it was radically changed with this legislative session, so let's look at what they said. Section A says a person commits an offense if the person intentionally, knowingly, or recklessly carries on or about his or her person a handgun. So key words here: intentionally, knowingly, or recklessly. Negligently is not a crime, and this is important. And if you're stopped, you'll probably be asked, did you know that you had a handgun? So if you forgot, you honest to God did not intend to carry it, it's not a crime. And that's similar to 4603, how it's been forever. That's why when you walk into a court or school or whatever, they ask you, did you know? And if you, I forgot to leave it in the car, they let you go. So that's an important thing. The next important word there is handgun. We're talking about handguns. We're not talking about rifles, shotguns, and I'm going to say submachine guns, and somebody out there is going to get pissed off about that and say those are not legal, whatever. It's the bottom line, we're talking just handguns here. I'm not here to argue about whether a submachine gun is legal to have or not. Subsection 2 is at the time of the offense is younger than 21 years of age. Okay? Or has been convicted of an offense under, and then there's a bunch of statutes there: 2201A1, 2205, 2207, 4201A7 or 8, committed in the 5-year preceding the date of the instant offense. So in other words, if you have a conviction of any of those crimes within 5 years, you can't be carrying even if you are over 21. If you're over 21 and don't have those convictions, then basically prima facie it's legal for you to carry a handgun, barring all the other laws, which we'll talk about later. And as the next part, is not on the person's own premises or premises under the person's control. And so that and is important, because what we're saying is if you're under 21 and you're on your own property, you would apparently be legal. Or even if you had a conviction within those 5 years and you're on your own property or premises under your control, which would typically be like a rented apartment, that sort of thing. And then it says, or inside of or directly en route to a motor vehicle or watercraft that is owned by the person or under the person's control. So again, in your vehicle or your boat, watercraft. Section A basically took away the illegality of having a handgun outside of your home or vehicle or boat. So that's how it used to be, was you could carry in your home, your property, between your property and your vehicle, as well as like if you had a business that was under your control, so not just you work somewhere, but actually like it's your business, then between there and your vehicle, or if you're riding a boat to work, I guess I'm sure somewhere out there there's somebody that rides a boat to work, so that would be covered as well. Subsection A1 was modified as well, and it says a person commits an offense if the person intentionally, knowingly, or recklessly carries on or about his or her person a handgun in a motor vehicle or watercraft that is owned by the person or under the person's control at any time in which, then subsection 1, the handgun is in plain view. Okay, so we're talking about basically open carry here. We're talking about plain view. I don't want to argue about whether you cover it with, you know, almost clear plastic bag or something. We're talking plain view. It's not defined. So, you know, if I was arguing on your behalf, I'd say plain view is plain view. I think you're asking for trouble if you've got it kind of partially covered with a towel or bag or something. I really think you need to be smarter than that and not try to push it, because you don't want to be the test case on any of these. Even if you win, ultimately, it's not worth your trouble. And then it says, unless the person is 21 years of age or older. Okay, so now we're talking about plain view, under 21, or is licensed to carry a handgun under the Texas handgun licensing law. And then it says, and, so this is important, the handgun is carried in a holster. Again, I'm not going to argue with folks about, does the holster need to be worn? Does it need to be worn properly? I mean, I know there's people that post on Facebook, they have a gun in a holster laying on their dashboard or on their passenger seat of their car or whatever. Again, maybe that's not technically illegal, but do you really want to be the test case there? It's probably not worth it to you, even if you win in the end. The next one is an or, and it says the person is engaged in criminal activity other than a Class C misdemeanor that's a violation of law or ordinance regulating traffic or boating. So basically, if you're out committing crimes, you better not have a gun on you. If you violate a traffic law, obviously they're not considering that to be out committing crimes, even though it's technically criminal activity in Texas to violate traffic laws. And then it says, or you're prohibited by law from possessing a firearm. I'm not going to go into all the details there. I mean, bottom line, it's usually felons and folks that don't have the mental capacity to safely handle a firearm or whatever. But we're not going to go into all those there. I'm assuming most of you watching are not prohibited from owning a firearm, so that's why you're watching, to figure out where you can legally carry. Now, they left alone A2, A3, and A4 from the prior statute, so I'm not going to really go over that. I'll just kind of briefly summarize. It defines premises there, and defines watercraft there. They don't define motor vehicle in the statute here, but like I said, I'm pretty sure my memory is correct that motorcycles are included in that definition as is used in 4602. And A4 is just talking about the knife carry law, and it's basically talking about under 18 carrying a knife. So again, we're not talking constitutional gun carry there. They did amend A5. They added an A5, A6, A7, and A8. So we need to talk about those additions. So A5, a person commits an offense if the person carries a handgun and intentionally displays the handgun in plain view of another person in a public place. It's an exception to the application of the subsection that the handgun was partially or wholly visible but carried in a holster. So I would say common sense, what they're talking about there is if you're walking around with a gun in your hand, carrying it around, again, handgun, not rifles. Rifles, shotguns, we're not talking about that for constitutional carry, we're just talking about handguns. So basically, it's legal to have it in a holster. Again, I would argue that you want to wear the holster properly and not just walk around with a gun in a holster in your hand or whatever. Not saying that you will end up going to jail or prison if you do that. I'm just saying you're asking for trouble with law enforcement if you're walking around with a gun and trying to be cute and carry it in your hand or whatever and say, oh, but it's in a holster. A6, person commits an offense if the person, 1, carries a handgun while the person is intoxicated, and 2, is not on the person's own property or property under the person's control or on private property with the consent of the property owner. So don't be drunk in public with a gun. And then it says, or, and I find this humorous, inside of or directly en route to a motor vehicle or watercraft, because you shouldn't be driving it drunk. But if you're drunk, apparently you can have your gun in your car. As long as that car is owned by the person or under the person's control. or with the consent of the owner or operator of the vehicle or watercraft. So I guess if you're drunk and have your gun and your friend will let you sit in their car with them, I guess you're technically not illegal. The bottom line, let's get serious for a second. You should not be intoxicated and handling a gun, right? I mean, let's just don't do that. A7 seems redundant on my initial read of it. There's probably a reason why they had to include it, but it's basically you commit an offense if you have a handgun and you're not allowed to have a handgun, which was mentioned earlier, but this one specifically refers to section 4604 A, B, or C, and basically those are dealing with felons and certain misdemeanor crimes. So again, I don't expect most of you watching this are falling under that one. Then A8, just again, it doesn't seem very applicable to most of us, and it's just if you are basically a criminal with a gun, you can be prosecuted under this statute or whatever other statute you're violating, which seems again redundant. So subsection B just says that a crime here is a Class A misdemeanor with some exceptions. Violating A7 is a felony, and I'm not going to go into all the details about that. I mean, like I said, bottom line, if you're watching this, you're probably a law-abiding citizen who's concerned about where you can or can't carry. In summary, if you have a concealed handgun on you, you're probably not violating 4602. If you have an openly carried handgun on you, if it's in a holster, and even though it doesn't say in the statute properly worn, just understand that the Supreme Court has said that officers can arrest you based on a misinterpretation of the law. In other words, you have to know the law, the officers do not. So if the officer thinks that it says the holster has to be properly worn, they can still arrest you. And if that happens to you, guess what? The arrest is on your permanent record, goes in your FBI file, and it never goes away. You could be prosecuted, you could be convicted, you might be successful on appeal later on. The Court of Criminal Appeals would probably overturn your conviction based on the language of the statute, at least the current makeup of the Court of Criminal Appeals. The problem is, do you want to be that test case? Do you want to go through all that? I know the answer for me is no. If you feel lucky and want to do that, that's on you. But for most of us, I would say open carry, have it in a holster that's worn properly, and if it's concealed, then it's concealed, and it can be in a holster or not in a holster. Just be safe. Obviously, if you pocket carry, I really recommend you have a pocket holster. If you purse carry, I really recommend that you have a pocket holster again, so that you don't accidentally hit the trigger. The main point of all of this is 4602 is just one statute, so we need to talk about all of them, and I will do that in the series of videos here. But bottom line, most public places you're going to be legal to be carrying, again, unless you're a criminal, engaging in criminal activity, in a gang, that sort of thing. But if you're just a normal citizen out and about, you're probably legal. Again, you're going to have to watch for signs, and certain locations like schools and courts are probably going to be off limits for you unless you're a peace officer, a judge, or prosecutor with a permit. And again, we'll talk about that in other videos. Hope this was helpful. Let me know in the comments if you have any questions, and I will do my best to answer them for you.